welcome back to the Eight Figure Attorney Podcast. I'm Seth Bader, and I'm really, really excited about our next guest. He is the founding partner of Shiver Hamilton Campbell. He is a trial lawyer with multiple 7- and 8-figure verdicts and settlements in the areas of commercial vehicle accidents, products liability, road defects, explosions, premises liability, wrongful death, and I'm sure a variety of other areas of practice. He is a very accomplished trial lawyer, one of the best right here in Georgia, and I'm so happy to introduce you to our next guest, Alan Hamilton. Welcome.
Thanks, Seth. Thanks for having me. I'm glad to be here.
So you were telling me a little bit about how the year got off to a start. That you've been working hard, skiing, entertaining lawyers, marketing. But how's the year treating you so far?
It's been a very good year so far. I lost. The big negative is I lost a trial date due to COVID.
Okay. That
I've been working on. I think it may be, and this is part of the deal, right? We take a case, we're going to work it up the way it needs to be done.
Right.
I've had, this is one of my favorite clients because he's been so long suffering and patient. COVID has now canceled 2 trial dates on him. We had a trial date, and then January, Omicron sort of derailed our plans in DeKalb County. So that was a blow because I was really looking forward to being back in the courtroom and trying a jury trial.
How long has it been?
I had one right before the pandemic.
Okay.
So now I've been in court a lot arguing things, and we've even done a couple of arbitrations and things to keep cases moving. But in terms of a full-blown jury trial, it's now coming up on, 2 years? Is that right?
Yeah, it's been.
Which has been the longest drought of my career, but it's really circumstances beyond all our control. And it's a constant reminder that life is full of things that none of us anticipated. I never would anticipate this last 2 years of court closures and the challenges with getting jury trials done. And so I'm ever the optimist that we're on the backside of it. But that's certainly been a challenge and an otherwise really fun and good year so far.
I'm sure that's been a challenge for you, but I'm curious, how do you counsel your clients who want a result and want some justice, when you keep having these delays?
Yeah, that is a very individualized and one of the things that I love about my practice being kind of small numbers of clients and cases. You really have a relationship with them. This guy's been with us 4 years, and we have really frank conversations, which is to say, if you've got a good case, we could get this thing resolved. And we try to really walk through with them what it looks like and let them make a choice. My desire is to maximize the result and get trial verdicts. And I try to be really blunt with clients. Like you and me have to separate my interest in jury trial, because it's what I do, from your interest in getting what's just and best for you and your family.
Sure.
And I always want to intentionally acknowledge that tension and set it aside. And so we talked in that case and others about, we can get you, the defense will resolve it, but they may want, they're a big insurance company, right? Sure. If they know trial's 2 years away, they're going to insist on some kind of discount on their risk for that.
Sure.
And so we just acknowledge what that is and talk about what the upside is of waiting and try to just empower the client to make the best decision for he or she and his or her family. So that's probably a long-winded answer to a straightforward question, but that's what we're trying to do in every case, every day.
Sure. Alan, I know you and I know your practice, but tell me and tell the folks that are watching just a little bit more about yourself. What you do and kind of how you got to this point.
Yeah, I come up in a family with really no attorneys. I don't have any legal background. My dad's done a lot of different things in business, but I went straight out of high school in Auburn, Alabama, to college, was on a track to do accounting, which I liked. I mean, it was kind of an interesting thing to study. But as I got to be 22 and I'm approaching graduation, I'm thinking, am I really going to do this for 20, 30, 40 years? I just didn't see it. So I decided to apply to law school and decided to go to the University of Georgia. Met Jeff Shiver, my now law partner, one of my partners, who he and I founded the firm together. My very first day, in Athens a long time ago now, over 20 years ago now. And from there, it really is, I would say, some good fortune or providence or whatever you want to call it. But I just knew in the tracks of law, I loved it. And I knew that I liked litigation and being on my feet and arguing things and being in court since I wasn't going to make it as a baseball player or a golfer or a winemaker, I was like, well, I'm pretty good at this, and this can make a go of this. And so I from there, I had worked at these big corporate defense law firms, which is great. And it's sort of the path. If you don't know what you're doing and you've worked hard and you're competing and you make good grades, that's kind of the path in front of you. So I had done that in the summers. And then through a variety of circumstances and relationships, I met some really great lawyers that had a really great trial law firm that offered me a job. And as I looked at it, I said, wait, I can help people. And despite, at 24, I looked like I was 14. So in the big firm, there's no way I was going to get in court representing for years, really, in a meaningful way. But one thing I loved about my bosses and mentors is our individual clients didn't have an expectation. They weren't calling the shots of who did what. So they were sort of always, my mentor was always kind of pushing me out of the nest and letting me do things in the courtroom at an early stage of my career that I didn't even think I was ready to do. And I try to do that with our young lawyers now. I mean, that was so impactful for me to have somebody believe in you and push you to your limit. And that really is a catalyst for everything I've done since.
Talk to me just generally about the areas of practice. I mean, I mentioned some of them at the opening, but what would you say are sort of 2 or 3 of your primary areas of practice?
Certainly commercial auto, focused on trucking, but everything from a log truck to dump trucks to pieces of equipment on the road, and just, work trucks and commercial vehicles that have high insurance limits. That's probably the bulk of my practice. Negligent security, premises liability is a major subspecialty of our law firm. It's something Jeff really has always shined at. So that's a major component of our business. And I really love and do a lot of workplace injury cases. Just everyone's different from we're involved in the liquid nitrogen spill up in Gainesville to I'm working on a bridge collapse case now, to explosions from combustible dust. We've done to a recycling plant fire. So those are always a legal puzzle and a factual puzzle, and that's where we I hope our attention to detail and our approach to working on cases to kind of learn new areas. And it's one thing I love about it is I'm always learning about a new business, a new industry I didn't know anything about. And you have to really develop some mastery of that to fit that into the framework of helping a client under Georgia law. And that's something that is a major focus of mine as well.
Do you have any recent results, like pretty significant results you can share with me?
Sure. In the trucking area in particular, at the end of last year, this was a case that we worked on. Thankfully, there were no real delays. The timing was right. We started the case at the beginning of COVID and sort of worked it through. And this was in a really small South Georgia county. But it was a great case. It was a wonderful client. Tragically, she died and left behind 2 young children. But it was so every day I think about still and thought about those 2 little girls. And we can't, you can't replace, you can't fix, but you can make a meaningful difference. I hope, I believe, I have to believe, make a meaningful difference with what we do in people's lives, primarily the individual kids or adults or whoever it is, and secondarily for safety generally, so that there's less people in that situation. But that case was a trucking wrongful death in South Georgia. And the only defense to the case from day one was this is a really small place where, a few $1 million is a lot of money. And not to minimize it, it is. But it's not in comparison to life. And life is worth no less in South Georgia than it is in a big city like Atlanta or New York, where we're used to people being paid $20 and $30 million to play a sport or write music or any number of other things. And so I just don't subscribe to the idea that a great case is worth less in a small place than it is in a big place. And that was our thesis from day one. And so we took in the case and said, this is a really good case. And we sent a demand within a couple of weeks and said the case is $30 million to settle this case.
And so you made a demand early in the case for $30 million.
Right when we filed, yes.
Right when you filed the lawsuit. And then what was the final outcome?
Well, it over the course, they wanted to, as well they should, they wanted to settle the case. Great, really lawyer I respect a ton was involved early on, and they wanted to mediate. That is, we talked about a little while ago. I talked with your partner about the rise of ADR and mediation, and that can be really effective in some cases. But we just didn't. We politely but firmly said we don't see that. When I told you that number, that wasn't a posturing. That wasn't a let's talk. That was real. So time may have to tell you that I mean that, but I mean that. And so they had offered $3 million, and we politely said no. And then they came back months later and offered $6 million and asked us to mediate again. And we said, same thing. I love you, but no. And we got closer and closer to trial. We got a trial date. We had a fantastic judge who was really attentive and moved the docket along, which is so important, right? You just regardless, you just want a fair judge that calls balls and strikes. I don't mean to say you need the rulings all your way. Of course, I like to think the motions we file and the positions we take should get the ruling, but just being able to move that along quickly, they later doubled the offer again and doubled it again, and they were, I think, at 20, and we were 2 or 3 weeks away from trial, and we just never wavered ever. And in fact, we said at one point, look, we're on the final stretch to the courthouse. We're working really hard on this nonstop. If you answer with anything less than $30 million, we're going to move up. And so after that, a couple of weeks before trial, we got the call, which I was frankly a little bit crestfallen because I really wanted to try that case. But at the end of the day, it was that $30 million result was a great outcome for the clients, and obviously I'm very pleased with that for their sake, for the good that will do in those girls' lives.
Again, I'm curious. You've got a client. Who were you representing at the time?
Well, the estate and the 2 little girls.
The 2 little girls. When you know that there's so much at stake for these young girls, how do you have the confidence to hold out when they're offering literally millions and millions of dollars? How do you stay firm in this case at $30 million, and how do you express that to the guardian or whoever it is that's sort of representing the estate?
Such a good question. And I go back to, we have to acknowledge and separate our desire to try the case and get the result, right? We love trying the case. The results also, the verdict is also good for our business. I mean, we're attorneys talking. That's just a reality. And so I talk to clients about that, but I also say to them, let's not let ourselves focus on the fact that they're offering a lot of money. If I gave you, a priceless painting, if you had that, or if you had, 1 million shares of Apple stock, would you sell it because somebody said, I'll give you $2 million for it if it's worth 50? Would you sell it because $2 million can change your life? It can change your life, but would you sell it because of that? Now, as you and I both know, there is more risk. There's no ready market to tell me or you what that case is worth. So it also comes down to having some faith and confidence in the system and in your own ability to present the case. That's certainly part of it. And we just talk about that too, really. I mean, we say, my heart and my gut and my head tell me the range of this case is here. The last thing though is you got to consider the client situation too. I mean, you can take more risk because it's kind of inside baseball here, but you can take more risk in a case where you're gonna win. You're gonna win, and if you're wrong, and it comes up on the relatively low end, your client's still okay. And you just have to have that conversation, right? And the upside versus the downside. It certainly helps when the downside is still going to be something that changes their life.
Sure. So let's talk about another case that I know was significant. There was a case you handled years ago. It was an explosion case. And I think did you represent an undocumented immigrant?
We did. A wonderful young man. His name was Eric Hilario. He was, I think, 19. So we represented his mom and his dad. So
first question, a lot of folks don't know that undocumented individuals still have rights to pursue these cases. Is that right?
They have not only rights, they have equal rights to everyone else.
And so tell me a little bit about the case. Don't want to get too far into it, but just enough to kind of explain what kind of case it was and how what your strategy was and ultimately the result.
Sure. So it's a premises liability case. I think it happened around 2014. The trial would have been in, I think, 2016 in Fulton County. There's right down near Hartsfield-Jackson Airport, there's a recycling plant where you think about metals recycling, they take in all kinds of stuff. One of the things they take in is old cars. And so they had this device built with this literal spike on it. They called it a puncher, where before they would push a car through their shredder to turn it into scrap metal, they'd pick up the car with a crane and smash down the gas tank on the spike to get the gas out of the tank. Well, as you can imagine, just from hearing that, it's not a very sterile process. You got gas and fumes and metal flying everywhere. And they would clean up the yard at night by using a front end loader to just use the bucket to scrape all the scrap out of the way. Well, on this particular evening, Eric Hilario was running the front end loader, and from gas that had spilled out on the ground and all the metal out there, we had a surveillance video of it. A spark caught and a just huge conflagration. I mean, just a huge fire erupted, and he tried to back out of there but couldn't get away, and died of his injuries. One of the most tragic pieces of it was his dad and brother worked there too. So they're there when they had to sound out the fire alarm and try to get everybody corralled and count everyone. So it was just as tragic as it could be as a set of facts.
Now, in that case, as I recall, you actually took an incredible not a deposition, but a cross-examination of a witness. So, is that right?
I think it was. I hope it was incredible.
I mean, your partner says you absolutely annihilated the witness. Before we get into that, I just kind of want you to explain what is a sort of basics. What is a cross-examination, and generally sort of what makes a really good cross-examination?
In general terms, at the most basic level, a cross-examination is asking questions of an adverse witness. So somebody against you. We sometimes will call an adverse witness. We do this a lot. We will call somebody that works for the defendant company in our case.
I see.
This was not that situation. This was the CFO of the company that the defense called. And without getting too far in the weeds on it, the real defense to the case was the workers' compensation bar, which is to say, if you're injured on the job in Georgia, you get automatic benefits for workers' comp, but you're the exchange for that is you can't sue your employer. So the whole premise of the case, this company had all these different entities set up, and they had one entity that owned the dirt, and we sued that entity. They had another entity that wrote the paycheck to our client and the other workers, separate entities. And so the defense was, well, really, the guys work for the company you're trying to sue, therefore you lose. So the jury was tasked with deciding who employed the people, which gets to this cross-examination. The guy was a good witness. We took his deposition, which is where you get to find out what they're going to say, and he was pretty compellingly explaining why we were wrong and all the people really worked for the company we were trying to sue, which was basically going to give us the trap door to lose the case. And this is just digging and hard work, but we went out and thought about, okay, he's saying that this company, the dirt owner, employs everybody. What kind of documents might undercut that out in the world? And we thought to go pull from the city of East Point all the business licenses and occupational tax applications and all that stuff, We went down and got those public records. And lo and behold, the company we sued, the dirt owner, they had an application for it. And the company that we said was the employer, they had an application for it. And so this one that we sued, guess how many employees? They had to swear how many, under oath, and it was this guy that signed it, how many employees they had. And they wrote 0. Wow. And they wrote 300 and some sworn for the other company. So that's the stage for that cross-examination.
Amazing. And I'm curious, after that cross-examination, was that sort of what led to the final outcome? Was that a key piece of evidence in the case?
I think it was. And the way it played, one thing I really believe in is if you have something really good, don't rush it. Yeah. Don't rush it. So the defense puts this witness up, and he has all these charts and graphs and spreadsheets and financials, and he's showing essentially that the company we're suing is really the employer. That's where all the money's made. And I started out just kind of, and I think this was on courtroom TV too. I started out just kind of walking him down the road of reiterating his own points, reiterating his points. And I, along the lines of, you're saying that today, and you would have said it last week, and you would have sworn to it last month and last year. Of course, it's just the truth, right? Yeah. And you would admit, you would agree with me that it's not okay to change your story to suit your audience. Sure. And these are just basic things. Of course, he agrees with it. And then we start to walk down the road of pulling out these documents. And then the defense calls this huge objection. The jury gets sent out for 20 minutes while the judge is deciding whether I can use this document, and they bring him back in. And I sort of force feed him the document and make him read the oath under penalty of perjury. How many employees did you swear to the city of East Point that Newell Recycling of Atlanta has under penalty of perjury? Can you read that? And I put it on the Elmo screen, and he said 0, and he's sweating. And so we had a lot of fun with that. And I know anecdotally from after the trial that several of the jurors wanted to find out if they could have him prosecuted for perjury, which is, so that tends to indicate it was at least a meaningful part of the trial.
Sure. Well, let's talk about something that I know you work on as well, and that I think these kind of cases are happening more and more. Uber and Lyft cases. Because there's a lot of folks out there that unfortunately have been involved in accidents, and I know you're handling a case like that right now, but can you just kind of explain sort of whether the Uber and Lyft cases, if they're different than a regular car accident case, or just what is significant maybe about the insurance policies that you look for if you're representing somebody who's been injured in a Lyft or an Uber accident?
Yeah, they are quite different than your garden variety auto case. In general, Uber and Lyft both place insurance on the drivers that are out there. They take the position, legally, that the Uber driver is not really an Uber employee driver. It's a contractor who's just using their app, just like you and me may be using their app to get